Welcome to Access and Privacy Online, the podcast where we delve into the latest issues, challenges, and advancements in access to information and privacy rights. I'm Patrick Farnsworth. Thank you for being here. FIPA's latest submission to the Treasury Board makes 9 recommendations aimed at turning federal access rights into something people can actually use. Joining us is Pascale Grenier, the UVic Law Co-op legal researcher who helped draw the submission together, along with FIPA Executive Director Jason Woywada. We'll discuss what needs to change, why it matters, and what Pascale learned through the process. Let's dive in. Pascale, great to have you here. Thank you for coming on the podcast. It's really good to meet you.
Good to meet you as well.
Yeah, thank you for being here. So Pascale, we'll just jump into the first question here. So for someone who has never filed a federal access request, what is really the central problem here? As far as like what FIPA concluded is not working, and also why a person should ultimately care about this process altogether.
Yeah, for sure. Coming into this research, I hadn't filed an access request before. I never worked with this kind of topic or done really any research about it. And so I was coming into it very new. So reading past FIPA submissions actually helped me a lot, and reading kind of what was identified in the past and what is still consistent now. And so I think a big thing was, resourcing, making sure that people can actually exercise, this as a right. The Supreme Court has identified that access to information is a tool that can, strengthen democracy, increase transparency between the public and institutions. But what the Information Commissioner report was showing was there's such high volumes of access requests, and institutions can struggle to kind of manage that capacity. And so just really making sure that there was those resources seemed to be something that was identified in the past, and then through the research again, more currently as well, from more recent reports that came up again as well.
Yeah, and I may have fumbled the question earlier. It was a bit of a twofer there, but what did FIPA ultimately conclude is not working with that?
Yeah, I mean, it's interesting from a research perspective. There wasn't necessarily prime examples of certain things that institutions are doing aren't working. It was more so identifying, these are maybe the tools that could help. And so proper kind of resources to smooth in kind of that management of the systems and kind of benefit the institution and the public, and making sure that they can manage that capacity, I guess, if that answers your question. Yeah.
Yeah. So for the average person, what are they getting from this resource? How is it helping them in this process?
Yeah. Figuring out, I guess, from them kind of reading through the issues, making sure or figuring out that this is a right, that it's available to them, and then just being able to kind of read through what needs to happen and understanding what consultations are happening.
Right. Okay.
Mm-hmm.
All right. So, regarding the reviewing of the policy proposals and the court decisions and evidence about the system, this question is really about what surprised you about that gap between having a legal right of access and actually being able to exercise it.
Yeah, for sure. Because you see a lot of commentary from the Supreme Court saying, it's an essential right, it's a very important right. And so then you have to look at, okay, what does that central and important right look like in practice? And one of the most significant factors that I identified in my research, particularly through TBS reports and Information Commissioner reports, was the wait times. And of course, it kind of depends on the size and the nature of the request as well. Lots of differences in the types of requests that institutions are seeing. But the Committee on Access to Information from Information Privacy and Ethics, they heard from lots of witnesses. And one of the bigger concerns was how longer timelines can kind of deter individuals from pursuing that, kind of seeing how, if the wait time is really long, kind of making them, question. That was one thing that came up a lot in that report, and something that surprised me the most kind of was the biggest barrier, biggest gap. And so it kind of ties back to the first question as well, as far as that resourcing and looking, from the institution's perspective and from the requester's perspective, what is going to work so that these can these two kind of bodies and sides can work together, and it can be beneficial for both.
Yeah. Okay. So I guess how did the project ultimately change how you understand or understood access to information as a legal subject, a public service, or as a democratic right?
Yeah, I mean, I think it took access to information kind of reconciled it as kind of all of those things. I mean, it is a legal right. It says that, in the Access Act, but it also is it's a legal right that comes with this process behind it. And so being able to kind of reconcile those two things was what came up in the research a lot, and what surprised me, because when I think people think about access to information means a lot of different things to different people, especially with the barriers that exist. And so being able to articulate that there's all these different sides to it was important.
So we're going to talk about really maybe what should change for those requesting, the requesters. The submission's most distinctive requester-facing recommendations are to define what, quote, every reasonable effort, end quote, requires, automatically disclose how requests are processed, and broaden the meaning of public interest. So that isn't really a question, is it, Jason?
No, I mean, the key thing here is, right, like, when we're looking at some of these things and framing them, I think the question that comes in here is the Act says institutions must make every reasonable effort to assist a requester. What should that actually require an institution to do based on the research and the recommendations when you were reviewing them, Pascale? What sort of stood out?
Yeah, I think it's not, and one thing I was learning in law school is that the word reasonable comes up a lot. It's not uncommon for the word reasonable to be in legislation, and for that to be undefined, and that there seems to be an understanding of what reasonable can mean in all these different contexts. And what I was looking at, and what we were looking at when I was discussing it with Jason in the research, is how other jurisdictions, in the context of access to information, what reasonable effort looked like, and how some jurisdictions paired reasonable effort with kind of explainers of what that would look like in that context. So in kind of a high level way, we looked at, in the UK, Scotland, New Zealand, the EU, and kind of how they articulated reasonable efforts with a duty to assist, to kind of clarify unclear requests, narrow, maybe overly broad requests, redirect misdirected ones, or explain certain procedural limits. And so it's kind of from the perspective of increasing that understanding, because access to information has so much to do with, a person approaching an institution that has all the expertise and knowledge of how it works, and the person, might not have that same expertise and knowledge. And so just being able to understand what reasonable efforts mean, also to understand the limitations, expectations, and all those things that can come with an access request, especially keeping in mind what might be invested for someone making a request. It might be for personal reasons, for work reasons, for all these different kinds of reasons. So having those clarifications, similar to what other jurisdictions have done, was the angle there.
Right. And do you see a need for there to be some balance in that to ensure that the public, who is sometimes worried about the government trying to withhold information, isn't unduly restricting their ability to access as well? Like, how does somebody who's making that request understand that there is a duty to assist without the need for them to constrain the request in an unreasonable way?
Yeah, I think with that one, good question. It was about looking just how, from the perspective of an individual, especially thinking about someone who isn't familiar with access requests, understanding the realities around it, and understanding what it could look like when they enter that process, and what is a reasonable effort versus what would be an unreasonable effort as well. And so I think it was mostly about knowing what expectations to have, and kind of using it almost as like a education resource as well, to say, okay, this is what the efforts look like in this process, and how they can then kind of formulate the request as well. to kind of best maybe take advantage of those kinds of efforts and all of that.
Well, let me ask Jason, why is it important that requesters be able to see this as a public standard rather than depend on the practices of whichever institution receives their request? It can be a little confusing, I think, from that angle.
Yeah, most definitely. And I think that's why we've called consistently for there to be greater transparency in the processing of these requests. And we'll get into this when we talk about immigration and refugee Canada and sort of the request dynamic that takes place there. Uh, but ultimately, one of the most consistent secondary requests that happens is to find out how a request was processed. And so it's really important that there be this transparency in a proactive way that enables an individual to see how their request was processed to prevent the need for them to subsequently file a secondary request to find out where their request is in processing, how it is being processed, and who had access to that request. And if there was some degree of greater transparency in proactive release of the information that pertains to the processing of requests, you would be preventing and in many ways lowering the burden in the system for secondary requests. And so there's one of these things that occurs where nobody has faith in the system in some respect because they don't know how their request is being processed. So they automatically file these secondary requests. And if you were able to, in a way, create a dashboard that allowed an individual to track their requests and understand how they were being processed, then the public would have greater faith in how their request was being processed, be able to know where they were at in the process, and wouldn't need to file these secondary requests that then increase the caseload that organizations are having to deal with. So, it's really important that that transparency be built into the system.
Well, to build on that, I guess I can ask both of you this question really, but whoever wants to jump in. But FIPA recommends that requesters automatically receive a summary. This is building on what you just said, Jason. Basically, a summary explaining how the request was processed. As someone who's largely unfamiliar with this myself, asking these questions, but I mean, is the process seems rather opaque. It seems rather difficult to know how this is actually happening. So, this recommendation that FIPA has, why is it important that there should be some kind of summary or some sort of ability to see through this, some sort of transparency? And what would that summary ultimately contain? I can maybe ask Jason first if you want to jump on that, building on what you said last. Yeah.
Yeah, and actually, based on what we saw at IRCC, and I think what I want to make sure I can highlight is Pascale's research in this, right? Like when you were looking at IRCC, Pascale, like what did you see as some of the most relevant stuff? And FIPA's done research in this regarding pathways to precarity from Jerica Katahata, who came through our office before. But this is a consistent issue that we're seeing in federal government, isn't it?
Well, when I was reading through the Information Commissioner reports, kind of based off of institutions, like there was Library and Archives Canada, IRCC was on there, a couple was on there as well. And what stood out to me was just, how much I think they accounted for, was it 80%? I can't remember off the top of my head, but a significant amount of the total access request received like from everywhere, from all the institutions. And so, as you said, there's people who want to, if they're receiving a large number of requests, that could also be because there's the follow-up requests that are happening as well. Because in situations like that, where depending on the nature of the request, someone might want to know why the outcome, and then they want to know kind of the steps taken to lead to that outcome. And so that's what that recommendation was speaking to a bit as well.
And we'll be sure to link to all of the reports that gave rise to some of these considerations in this. But the Pathways to Precarity report really sort of dove into that issue that we see in other government reports about the sheer volume of requests that are hitting IRCC on a regular basis, why those are occurring, and how that leads to diminished capacity in the rest of government because there's such a burden that is hitting IRCC from the lack of transparency in the way that they are processing these things. And so it really does speak to a dynamic where the most important requests that hit government are for personal information, and for people that are making refugee claims or seeking immigration status or seeking their personal information that public bodies hold in the federal government. They want to be able to know where things are sitting and how they're getting access to that. And government's inherent lack of transparency there is forcing them into an FOI system. And the instant they're forced into that FOI system, it increases the burden there, and that diminishes resources for other activities and other general requests. And so this is one of the dynamics that we're really starting to see play out in these dynamics, where government's lack of transparency in the processing of personal information requests, or making sure that personal information is released in a more systematic way to the people that it's being collected from, is leading to a lack of transparency, and then stopping transparency in other areas. And it's a larger issue for sure, one that we drew attention to in this, one that we've been looking at for a while. In Pathways to Precarity and in this latest TBS submission, we're hoping that they'll take some steps to address it.
So Pascale, the current provision focuses heavily on public health, safety, and environmental protection, and the recommendations call for public interest to be understood more broadly. So what gave rise to that?
Yeah, public interest, again, is one of those things where can be public interest in so many different contexts. And so figuring out what that means for access can be really tricky, because there's so many really important, necessary things to balance and to consider. And so looking from, the court's perspective, and all that, has acknowledged that there's this relationship between access rights and then, freedom of expression under Section 2B, especially when kind of looking at the underlying purposes of it: democratic discourse, self-fulfillment, truth-finding, all those things. And they've said that, freedom of expression does not necessarily guarantee access, to documents that are in the government's care. It doesn't mean, freedom of expression is not so intrinsically tied to access to information, but there is a relationship. And so there's kind of access based on a precondition of, if that access fosters meaningful expression, it doesn't encroach on protected privileges, and it's compatible with the function of the institution. And so there's this question of balancing the confidentiality considerations of certain information, because public interest can also mean not releasing information as well. That can also be in the public interest. So it's through kind of researching and looking for this, it's difficult because there's so many things to balance to find, a concrete answer of what it means when public interest is a bit more broad beyond what the provision says. But I think it's about, asking more questions and figuring out kind of what works best, considering the perspective of the public and the institution. So it is one of those questions, unfortunately, that doesn't have necessarily set answers, but just how to broaden that understanding, thinking about, what more can we ask when figuring this out, when there's lots of very sensitive and important things that can be at stake with this question.
Yeah. Mm-hmm. And so does the research illuminate some of this ambiguity that you're describing, or the kind of spaciousness of this definition?
Yeah. It didn't necessarily, nothing super concrete, but I think it more gives maybe a bit more of a guidance in terms of when situations come up, when something could maybe be in the public interest. It provides more questions to ask. Does this contribute, when we're considering, is it compatible with the function of the institution, for example, or does it encroach on protected privileges, like how the courts articulated that? It gives more narrowed questions to ask, I would say, is kind of what the research presents. And then it might be, a case by case or specific analysis or consideration.
Yeah. Okay.
Yeah.
I think it's important to consider with this one too, right? Like currently it's based on this threat to public health, safety, and the environment, right? That's a big part of access to information in a current dynamic in a public interest balancing. And when we've been considering this on an ongoing basis, there's a couple of false comparisons here, right? Public bodies presume that because they do it, it's in the public interest, and that is absolutely a false equivalency there. Just because a public body doesn't mean that it's in the public interest. And when we look at other analytical frameworks within public bodies, they have gender-based analysis, they have Indigenous reconciliation analysis documents that that they work with on a regular basis when they are looking at implementing new programs and ideas and concepts. And yet we see an absence of public interest analysis when they are undertaking some of these things and when they are looking at some of these dynamics. And so I think that's why FIPA has so consistently gone back to look at why public interest, which is meant to be paramount, is considered more broadly, that there needs to be some analytical framing that is put in place there, and that there needs to be some sort of consideration that is done systematically at every opportunity to ensure that the information that is garnered, collected, and available is analyzed for proactive release in the public interest. Because so often now we see competing interests leading to a lack of transparency, and whether that's business interests of a third party or classification of confidential information that might harm intergovernmental relations with other organizations. There's lots of exceptions that are increasingly being applied to prevent the release of information, and less evidence, if you will, of proactive interest or public interest being proactively applied in the release of information. And I think that's a really important consideration why we keep going back to this, because if public interest is paramount, it should be considered and implemented in a proactive manner. And we don't see evidence of that. And increasingly, we see evidence to the contrary. And so that's why we so consistently go back to this. And it is a bit of a chicken and egg scenario, because, when public bodies start by saying everything we do is in the public interest because we're a public body, and yet there's evidence to the contrary of that, and the public doesn't trust them anymore because they haven't been transparent, and a whole bunch of other factors that give rise to a lack and erosion of public interest. One of the elements that we know addresses trust is transparency. And so that's why we keep going back to this importance of reevaluating public interest, applying it more broadly, and considering that public interest, to be understood more broadly, needs to be considered outside of purely a threat to public health, safety, and environmental protection. Given climate change as an example, right? And the scientific evidence and the information that's available, there's a lot more information that should be being released when we consider pipeline development, right? Or the impacts on pipelines to climate change that could give rise to more forest fires and more people being evacuated from their homes in British Columbia, right? So there's all of these dynamics that are in the mix that aren't necessarily being considered. And we need to make sure that the public is first and foremost in those considerations. It's one of the things that we've needed to make sure that we consider in drafting our recommendations as well.
Absolutely. Yeah. Thank you for all that information, Jason, going over the specifics of that. But Pascale, I wanted to ask you, regarding these consultation recommendations, what really should happen with them?
Yeah, I know that there's a lot of time, resources invested in doing these kinds of recommendations and gathering all of the information and then putting it, packaging it in a coherent way that makes sense after hearing from all the different witnesses that take time to attend all these sessions and all of that. And I know that in the past, FIPA advocated that, there's, emphasize at least, the value of these recommendations. And so, as someone, kind of junior researcher, legal researcher, my knowledge, on the realities and the capacity to implement these recommendations is limited, and why certain are implemented and why aren't, and all of the factors that go into that. But I know that in this submission and in past submissions, and kind of the recommendation itself from the committee really just emphasizes the value of being able to take the temperature on what the public are thinking about certain things. And so I don't have a direct answer as to, what really should happen, being mindful of, my knowledge on
Sure.
how these actually get implemented and that kind of thing. But I think, standing from a research perspective and what the committee says, of just kind of emphasizing the value of them, and then even maybe being able to understand why they're implemented, and why certain ones are implemented, and their degree and all that kind of thing is about just maybe increasing that understanding. And yeah.
Yeah. Well, yeah, you're being humble there for sure. Yeah, I guess just to follow up on that, and again, Jason, feel free to flesh this out if you need to. But again, to Pascale, as you mentioned, the governments regularly conduct reviews, and they hear witnesses, and they receive detailed submissions.
Mm-hmm.
So, any thoughts on what a government should be required to do with those recommendations?
Yeah, I mean, I know that when they conduct the recommendations, like with the Access Act review, they pulled from the consultation with the committee and read it and considered those. And so they are, considering them, reading through them, and all of those things. I think it's about what they should be required to do, but also about asking more questions about, what does that look like realistically for them, and how can, understanding, I guess, be increased between how that process works. When you kind of undertake a big research project and, present all this information, it's of course understanding researchers' position and that information versus, the implementation and everything that goes into that. And so, yeah, again, I think it's just one of those situations where it could be very case by case, and just having that understanding and acknowledging the value of those, which is, underway and all that, and seeing that they are, implementing recommendations. And I think that being able just to kind of, again, it's all about increasing that understanding. Yeah.
Absolutely.
What I'd like to add to some of this right now is that what I've been seeing with the recommendations and these types of consultative processes is TBS is increasingly coming forward with these lists of 25 questions or 30 questions that they want to have answered. And there's an increasing disconnect between what they are seeking input on and what civil society and the rest of the population are identifying as issues. And so when TBS is asking, in this very limited instance, to come in and look at the legislation in a very limited way, the public is left looking at that as an overly narrow review of the legislation in a time frame that is sometimes really compressed. And that is leading to a lot of frustration in civil society right now. There are a lot of other members of civil society that we've spoken to outside of this process that are disappointed in where they see Treasury Board going with this. And in the off chance that they happen to hear this interview, I'd like to highlight to them that this doesn't engender trust in what they're doing. Because what we saw was they have these 25 questions and we address some of them, but then we are identifying all these other areas that this is what we'd really like to talk to you about. And this is what we're hearing and identifying in our research as core issues impacting access to information. And so we need to have both of these scenarios available in a civil society, in a Westminster system. We can't just open up legislation under 2 or 3 clauses to say we're amending that and we're not changing anything else when there's other problems identified. And I think that's been part of the issue that is increasingly occurring in civil society with these things. We're not, all the great work that Pascale has done in drafting these recommendations for us reflect both of those things. We've addressed specific questions that TBS raised, and we've been able to go in and address some of the broader questions that we've identified from our extended network.
Yeah. All right. So, Jason, speaking to the recommendations that FIPA made a recommendation in number 9 that parliamentarians should reduce their reliance on ATIP. That's considered a controversial take. So why should MPs not simply be told to file an ATIP?
So the reason we considered this and wanted to make sure we included this as a recommendation is in part because of the research that we've been looking at in voter privacy and in a whole bunch of other areas as well. And we've seen consistently that there were a lot of Hansard records where members of parliament are being told to file ATIP requests. Their staff are making ATIP requests. And they are frequent requesters under the general system. And a big dynamic that comes in with that is every time an MP makes a request through ATIP, that draws down resources that other members of the public have available to them to make requests. It reduces the available, this isn't an infinite amount of resources to process ATIP requests in the federal government. And so every time an MP makes a request, it reduces the available resources for other people to make requests. And so there's two solutions to that. One, they need to increase resourcing writ large. But two, MPs have an entire other set of request mechanisms that the general public doesn't have. And so that's why it's so important that they use every tool that they have available to them to make those requests to get the information they're seeking. And that includes committee meetings, that includes order paper questions, that includes question period, that includes written questions on the order paper. So those are tools that the general public doesn't have access to at all. All the public has access to is ATIP. And MPs have ATIP and. So it's important that parliamentarians use every tool before they use ATIP rather than default to using ATIP before they use these other tools. I think that's the primary dynamic there. And every citizen in Canada can make an ATIP request, and that's why it's important that MPs still be able to do that. But it's also important that they recognize the extraordinary powers they have as MPs in their caucuses and as backbenchers in a government to make requests for information and get access to that information.
And does that weaken Parliament's accountability or their role in accountability?
I think it increases the role of Parliament in accountability. And I think that's a really important dynamic in this regard, because there's been, and you can turn to Andrew Coyne or other people on this topic, there's been a lot of research that points to the weakening of the parliamentary system in a Canadian context. And MPs have a lot of extraordinary powers to compel the release of information through parliamentary procedure. But they have been very slow to do that in recent history. And it would perhaps be wise that they returned to using those extraordinary powers that have been granted to them. So I think that's really why we wanted to make sure that we highlighted this as a recommendation, recognizing that they make a lot of ATIP requests. They're important, but that they also have other tools to gain access to that information, and that the speaker has a role in enabling them to get access to that information as well.
All right, Pascale, so you had to reconcile requester rights, institutional capacity, court decisions, privacy and commercial interests, stakeholder feedback, and administrative feasibility. So what was the most difficult issue to bring together into one coherent recommendation?
Yeah, I think looking through, when researching, kind of looking through all of the different sources of information for each recommendation, where that came from, looking at public interest just had the most kind of to read about and to consider, and a lot of court commentary on it. And so kind of keeping in mind, what Jason had said to, kind of communicate and what to highlight and what to look for. I think that was the one where there was just so many different things. Again, even in kind of answering the public interest question, there isn't always necessarily a set formula or questions that work every single time in all these different scenarios, because there's so much balancing between, what the courts have acknowledged, how access and freedom of expression tie together based on those conditions and those tests, and then the confidentiality concerns. And so I think that was the one, kind of to present all of the research on it was kind of difficult to articulate, in a clear way, because it is a thing that requires, so much of looking at two sides. And so I would say that one was probably the hardest, just because, there was so much on it and so many different things. And
Okay. And so which recommendation developed or changed the most as you conducted this research further and then received feedback on that?
I think it was one of the first ones about reasonable efforts and defining those reasonable efforts. Initially, it was just a smaller kind of recommendation. And then as we considered more where to pull from, starting from, legislation in Canada, but then also looking at legislation in different jurisdictions. And so that one, we just were able to kind of articulate, incorporate more details and more kind of concrete examples of what that meant. Because again, you see the word reasonable a lot in kind of legal contexts, and that can mean different things, based on the context. So that one, it was just about kind of narrowing it, figuring it out. So there was all these things to kind of add on.
So what did you learn about the difference between identifying a legal problem and designing a recommendation that government could realistically implement?
Yeah, I think what was really helpful was looking at the templates that the TBS had available, and seeing kind of the different considerations that go into recommendations versus just going through research, seeing commentary on certain topics and then fleshing it out into a recommendation versus what does that then look like in a government context and what goes into the implementation. So I think it was just learning, that there's lots of different steps involved in that kind of identification, especially considering when you're doing research for a certain purpose and trying to speak to to like the organization's perspective, and doing research that, what's the word I'm looking for? Like speaks to that, I guess, not really the word that I was looking for, but I'll put that in for now. That speaks to that, and that can highlight it. So I think it's just, there's a lot more considerations to put it in a broad sense when you're looking at a legal problem, versus there's like a translation almost, I guess, that happens when you add in the extra factors of resources behind, like what resources are going to be needed behind certain implementations and things like that.
And so, how did you keep the requester's perspective visible while working through this very highly technical policy material?
Yeah, we've been able to do like consultations and some advocacy work through just like separate from the submission in different projects. And I've had the opportunity to listen in on consultations and hear about some of the concerns that people have when filing access requests and some of the obstacles that they ran into and what their experiences were like. And although, experiencing filing an access request, again, based on the nature of it, can look really different. And so, there's all that to consider as well with case by case. But hearing about, their experiences really kind of personalized the research for me, especially as someone who hasn't filed an access request before. And it made me, I was able to make connections between what the research was saying and then what I was hearing in these consultations. And so that helped kind of really reconcile and speak to, what I'd heard firsthand from what people were struggling with. And this was in the context of more kind of personal access requests versus, access to information in a more kind of general sense. But it just really helped inform, my research and made it kind of grounded it in a more realistic setting as to what people were saying, and then what these different sources were coming up with.
Okay. Mm-hmm. All right. Yeah. Okay. So just as we conclude here, we just have two questions. And I'll first ask you, Pascale, a question, and then we'll go to Jason. So Pascale, as a law co-op student at FIPA, what did this activity contribute in your understanding and how public interest legal research really differs from what you maybe learned in the classroom or, classroom legal analysis?
Yeah, I think that it definitely highlights, okay, this is why I'm learning these things from, bringing it classroom into the real world and learning with all those resources. But I think it definitely differs mostly in the consultation level involved. And also from my perspective, I think I'd been working doing legal research at FIPA for only a couple of weeks. So I still had to familiarize myself with past submissions, with the organization's viewpoint, and figuring out kind of what resources to draw from, and then considering, the recommendations that were given to me from Jason, from Mike, and understanding how, how that was going to guide my research and familiarizing myself with that first and laying that foundation, then jumping into it versus in a classroom, you can form, a position on something or do research for a variety of reasons, whether it's, because of the amount of sources available on a viewpoint or, lots of different reasons. Versus before even looking at the policy proposals, there was the familiarization, oh my goodness, with what FIPA had said, on this issue that had to happen first so that I knew what to research exactly. And then again, yeah, just that constant kind of consultation, as, Jason was saying, okay, yes, these sources are working versus, okay, here's a couple more, as we were getting kind of more pointed and specific as the submission was kind of trudging along and all of that, versus in a classroom, I'm not necessarily kind of going to my professor and saying, does this highlight like your perspective? And, from the recommendations you gave me, are these the right sources to be looking at? So I did appreciate that a lot, that kind of consultation that you don't always get in a classroom setting, unless that's kind of part of the assignment or something. So yeah, I'd say just the collaborative aspect is the biggest one. Yeah.
Did you say you've only been really doing research with FIPA for a few weeks? Is that what you said?
Yes.
And now you're being thrown into a podcast. Incredible. Yeah. Okay. All right. Well, thank you for that. Appreciate all that you've shared in this, in the research that you've done and everything. So yeah, thank you for joining us. But to Jason, final question to you. So what measurable results should Canadians expect to see if the reform is working? There's a few examples here. For example, fewer overdue requests, fewer complaints, clearer processing records, broader disclosure, or greater public confidence.
Yeah, and I think if the system is meaningfully changing, we will see both public trust increasing and information being made more available to the public. And ultimately, those two things are tied in all of the research that we've been seeing. And so that, I think, is going to be a really important dynamic. The government can walk and chew gum simultaneously. They can both restore trust from the public and release more information, and prevent the constant ability for those people trying to erode trust in public bodies to say that they are being secretive and lack transparency and are working against the public interest. Because we know that the vast majority of public servants are not doing that. We know the vast majority of public servants are indeed trying to work in the public interest and are indeed trying to be good civil servants in that respect. And I think it's important that we don't give in to those conspiracy theorists that are out there trying to cast aspersions on our public institutions, while at the same time trying to hold them accountable. And the only way we can do that appropriately is by getting access to the information. And so it is a balancing act that we recognize in these things. But in a Westminster system, and in Canada in particular, it is about peace, order, and good government. POG is a test, and good government is an important dynamic in that consideration. And we do have faith that our public institutions are working in a public interest. We just need to see some solid evidence of that and that they're considering it.
Yeah, and as far as all the resources regarding this from this discussion, I'm sure we will have those all available on the website and in the show notes, so people can check this out themselves. Yeah, Jason? I just
want to really, and if there's any way to include this, I just really want to make sure that we are appropriately thanking Pascale for all the work that she did in pulling this together, because it was very much into the deep end of the pool with this research right off the bat, coming in as a law co-op student in FIPA and then quickly having to turn this around for us. She did an exceptional job in doing that, and engaging our network and getting that information pulled in. And we're incredibly appreciative for the solid work that she did in pulling that together for us.
Thank you so much. I appreciate that a lot.
Yeah. Pascale, thank you for coming on Access and Privacy Online today. for our commentary. Really appreciate your research and work. Thank you for diving into the deep end, as Jason said, of the research. Jason, of course, thank you for joining us and sharing your insights into this as well. All right. Thank you both for being here.
Thank you.
Access and Privacy Online reviews the headlines and delivers deeper commentary on a regular basis. Be sure to subscribe to get the full episodes every week and get notifications when we release show segments and other commentary throughout the week. We look forward to hearing from you soon. Have a good one.